Trump Legal Cases Daily Digest, January 18, 2024. Hello and welcome to News Media Hant's Daily Digest. This week Trump's legal calendar focuses on the E. Jean Carroll defamation case, Tuesday, Maine ballot disqualification appeal written decision, Wednesday, Colorado SCOTUS 14A, last day for Trump brief and last day for Amicus Curiae briefs, Thursday, Probable DC Circuit merits decision in Trump presidential immunity, Friday, Maine 14A, last day for Trump notice of appeal filing to the decision of the Superior Court, Saturday. Today, Trump's legal team submitted the Amicus Curiae brief to SCOTUS as expected. Stay tuned for more developments on these cases. The E.J. Carroll defamation case is underway. During the hearing on Thursday, an expert witness testified that repairing E. Jean Carroll's reputation with those who believed former President Donald Trump's allegations could cost up to $12.1 million in damages. The jury will decide how much money Trump will have to pay Carroll. The court will be closed on Friday and the trial will resume on Monday following the testimony of Northwestern Professor Ashlee Humphreys, according to CNN's Dan Berman. Trump attorney challenges experts' analysis, emphasizing Carroll's role in public perception. In a courtroom confrontation, Donald Trump's attorney, Michael Medallo, scrutinized Northwestern University Professor Ashlee Humphreys' analyses, questioning the impact of E. Jean Carroll's actions on the public's perception of her. Medallo suggested that Trump supporters would likely remain skeptical of Carroll's story irrespective of the former president's statements, citing confirmation bias. He emphasized that Trump never publicly addressed Carroll until he denied her allegations following the New York Magazine excerpt in 2019, challenging the narrative that Trump's statements were the primary driver of public opinion. Amid objections from Carroll's attorney, Medallo pressed on, highlighting an excerpt from Humphreys' trial reports acknowledging Carroll's role in shaping public perception. The report noted, while some shift was attributed to the publication of her memoir and New York Magazine piece, Mr. Trump's response, and not her initial claim, resulted in the escalating attention that she has received. Medallo also questioned a word cloud data visualization in Humphreys' report, emphasizing terms like lying and money were less frequent compared to more generic terms. This line of questioning aimed to challenge the notion that negative associations with Carroll were solely attributed to accusations of dishonesty, suggesting a broader and less prejudiced public perception. The intense exchange underscored the strategic efforts of Trump's legal team to cast doubt on the cause and effect relationship between Trump's statements and the shifts in Carroll's public image. By highlighting Humphreys' acknowledgement of Carroll's own role, Medallo sought to present a nuanced perspective on the factors influencing public perception and reputational damage in this high-profile defamation trial. Trump's legal team challenges the feasibility of Carroll's reputation restoration. In the latest development of the defamation trial, Trump's attorney, Michael Medallo, challenged Northwestern Professor Ashlee Humphreys over the practicality of her analysis, disputing the proposed $12 million cost for E. Jean Carroll to repair her reputation after Donald Trump's 2019 statements. Medallo homed in on the intricacies of the reputational repair campaign Humphreys designed, specifically questioning the viability of enlisting conservative media figures like Joe Rogan and Candace Owens to disseminate positive messages about Carroll. Medallo's probing raised doubts about the effectiveness of such a campaign, emphasizing Humphreys' acknowledgement that both Rogan and Owens are available for paid media messaging. The attorney's inquiries delved into the complexities of influencing public opinion through media personalities and sought to challenge the credibility of the proposed multi-million-dollar reputational restoration effort. Despite Judge Lewis Kaplan's frustration with some of Medallo's questions, the cross-examination highlighted the legal strategy of dissecting the feasibility and practicality of the expert witness's recommendations. Concluding the cross-examination, Medallo pointedly asked Humphreys about her recent decision to make her Twitter account private, suggesting a potential awareness of negative backlash. Humphreys confirmed the action was taken in anticipation of her testimony in the high-profile trial, adding a layer of intrigue to the expert's role and the dynamics at play in the courtroom. Trump's Supreme Court battle, defending ballot access amidst 14th Amendment challenge. In a significant legal maneuver, Donald Trump has urged the U.S. Supreme Court to reverse the Colorado Supreme Court's ruling that disqualified him from the state's Republican primary ballot based on the 14th Amendment's insurrection clause. Trump's legal team, in a 59-page brief, cautioned of potential chaos and bedlam and argued that allowing states to disqualify him from the 2024 primary and general election ballots could disenfranchise millions of Americans. The former president contends that Section 3 of the 14th Amendment, barring individuals who engaged in insurrection from holding office, does not apply to him, emphasizing his calls for peace and law and order. The legal battle, scheduled for oral arguments on February 8, poses a pivotal question about Trump's eligibility and holds broader implications for the electoral landscape. As the Supreme Court navigates the intricacies of the 14th Amendment, Trump's lawyers challenge Colorado's interpretation and emphasize that the consequences of disqualification could extend beyond the state's borders. Notably, the court's decision could influence Super Tuesday on March 5, making the case a focal point in an already complex legal landscape related to Trump's post-presidential activities in the aftermath of the Capitol attack on January 6, 2021. Judge McAfee calls hearing on prosecutors' alleged misconduct. Fulton County Judge Scott McAfee has taken significant steps in response to accusations of misconduct by District Attorney Fani Willis in the landmark racketeering and conspiracy case against Donald Trump. Scheduled for February 15, the hearing will address claims that Willis engaged in a romantic relationship with Special Prosecutor Nathan Wade, a key figure in the case. Co-defendant Michael Roman, part of the group indicted in August for allegedly orchestrating an illegal attempt to overturn the 2020 election, has sought Willis's removal, arguing that her involvement with Wade violates ethics rules. McAfee's order also mandates Willis to formally respond to Roman's charges by February 2. The allegations, including claims of shared vacations and a romantic connection between Willis and Wade, have added complexity to an already high-profile case. While the case may not be dismissed outright if the claims are proven true, it could lead to Willis's disqualification, and, per Georgia case law, the entire Fulton County District Attorney's Office might also face disqualification. The scandal underscores the need for a thorough investigation into the potential conflicts of interest, as raised by Roman, and raises questions about the integrity of the prosecution in this politically charged legal battle. Thanks for watching. If you like it, comment and hit the like and share buttons. Subscribe for future videos.